Good morning, sir. Good morning, classmates. We are Group 6, Fortes, Suarez, Trazona, and Vista, and we are here to discuss on the continuation of the cases in Article 3 of the 1987 Constitution. As the first to report, here are my cases. First, People versus O'Coughlin, which is under search and seizure. Number 2, Zulweta versus Court of Appeals, under privacy of communications. Number 3, Morphe versus Motok, privacy of communications. Number 4, Gingging versus Court of Appeals under freedom of expression. And number 5, Tordesillas versus Honorable Puno under freedom of expression. The first case, People versus Occoquan, which is penned on December 10, 2019. The facts of the case are as follows. Iana Occoquan was a 53-year-old Irish national married to a Filipina and residing in Badoc, Ilocos Norte. He was charged with illegal possession of marijuana. While on his break around 7 p.m. on July 14, 2013, Special Security Officer Sugitan of the Department of Transportation, Office of Transportation Security, assigned at the initial security screening checkpoint at the Luwag City International Airport, was told by CSI Flor Tamayo that the parking space in front of the departure area smelled like marijuana. He suspected that Iano was the one who smoked the illegal drug, recounting that around 6:35 p.m. he saw a certain male Caucasian at the parking area lighting something unrecognizable as he was covering it with his palm. CSI Tamayo observed that whenever he would suck what he seemed to be smoking, no visible vapor would come out from his mouth. CSI Tamayo reported that he CSI Tamayo reported what he saw to PO2 Kaule and SSO Balot, who were the people manning the final screening area. Later on, SSO Balot directed SSO Sugitan to proceed to the final security checkpoint. The latter was instructed to conduct a pat-down search on Ayana, who then agreed. He was frisked while he raised his hands by stretching sideward to the level of his shoulders with palms open. When something was felt inside the pocket of his upper garment, he was asked to take it out. He then brought out a pack of Marlboro Red from his left pocket, as well as a matchbox and another pack of Marlboro Red from his right pocket. The pack of Marlboro Red on his left hand contained cigarettes, but the one on his right hand contained two rolled sticks of what appeared to be dried marijuana leaves. Sugita knew it was marijuana because that was what CSI Tamayo earlier told him. He took the pack of Marlboro Red containing the two rolled sticks of dried marijuana leaves and showed it to PO1 Manadao and other police personnel on duty. Sugitan put them on the nearby screening table in front of Iana and PO1 Manadao. The two rolled sticks of dried marijuana leaves were the only items placed thereon. So the issue in this case is whether or not instant airport screening search was a constitutionally reasonable administrative search, and whether or not there was a valid warrantless search. The ruling in the first issue was no. Although an airport screening search is sustained as a constitutionally reasonable administrative search, the instant case does not qualify as a legitimate administrative search in an airport. Airport search is reasonable when limited only to the scope, to the subject, or to the object of the anti hijacking program, and not the war on illegal drugs. Unlike a routine search where a prohibited drug was found by chance, a search on the person of the passenger or on his personal belongings in a deliberate and conscious effort to discover an illegal drug is not authorized under the exception to the warrant and probable cause requirement. The Supreme Court states that it is not empowered to suspend constitutional guarantees so that the government may more effectively wage a war on drugs. If the war is to be fought, those who fight it must respect the rights of individuals, whether or not those individuals are suspected of having committed a crime. In this case, what was seized from Iana were two rolled sticks of dried marijuana leaves. Obviously, they were not explosive, flammable, corrosive, or poisonous substances or materials or dangerous elements or devices that may be used to commit hijacking or acts of terrorism. More importantly, the illegal drugs were discovered not only during the final security checkpoint after a pat down search was conducted by Sugitan, who did not act based on personal knowledge but merely relied on the information given by CSI Tamayo that Ayana was possibly in possession of marijuana. In marked contrast, the illegal drugs confiscated from the accused in the Johnson case and subsequent cases were incidentally uncovered during the initial security check, which was in the course of the routine airport screening after the defendants were frisked or the alarm of the metal detector was triggered. For the second issue, the ruling was yes, there was a valid consented warrantless search in this case. The constitutional immunity against unreasonable searches and seizures is a personal fight which may be waived. A person may voluntarily consent to have government officials conduct a search or seizure that would otherwise be barred by the Constitution. In this case, the court finds that there is a valid warrantless search based on express consent. When Sugitan requested to conduct a pat down search on Iana, the latter readily agreed. Record is devoid of any evidence that he manifested objection or hesitation on the body search. The request to frisk him was orally articulated to him in such a language that left no room for doubt that he fully understood what was requested. Unperturbed, he verbally replied to the request, demonstrating that he also understood the nature and consequence of the request. He voluntarily raised his hands by stretching sideward to the level of his shoulders with palms open. His affirmative reply and action cannot be viewed as merely an implied acquiescence or a passive conformity to an authority, considering that SSO Sugitan is not even a police officer and cannot be said to have acted with a coercive or intimidating stance. Further, it is reasonable to assume that Iana is an educated and intelligent man. He is a 53-year-old working professional and a well traveled man. Indubitably, he knew actually or constructively his right against unreasonable searches, or that he intentionally conceded the same. Having been obtained through a valid warrantless search, the sticks of marijuana are then admissible in evidence against him. Colorally, his subsequent arrest, although likewise without warrant, was justified since it was effected upon discovery and recovery of an illegal drug in his person in flagrante delicto. The second case is the case of Zulueta versus Court of Appeals, and it is under the subject of privacy of communications. So this case is a petition to review the decision of the Court of Appeals affirming the decision of the RTC of Manila, which ordered petitioner to return documents and papers taken by her from private respondent's clinic without the latter's knowledge and consent. Petitioner Cecilia Zulveta is the wife of private respondent, in this case, Alfredo Martin. On March 26, 1982, petitioner entered the clinic of her husband, a doctor of medicine, and in the presence of her mother, a driver, and private respondent secretary, forcibly opened the drawers and cabinet in her husband's clinic and took 157 documents consisting of private correspondence between Dr. Martin and his alleged paramours, greeting cards, canceled checks, diaries, Dr. Martin's passport, and photographs. The document and papers were seized for use in evidence in a case for legal separation and for disqualification from the practice of medicine, which petitioner Zulweta had filed against her husband, Dr. Martin. The issue in this case is whether or not the documents and papers in question are inadmissible in evidence. The ruling is yes. The documents and papers in question are inadmissible in evidence. The constitutional injunction declaring the privacy of communication in correspondence to be inviolable is no less applicable simply because it is the wife who thinks herself aggrieved by her husband's infidelity, who is the party against whom the constitutional provision is to be enforced. The only exception to the prohibition in the Constitution is if there is a lawful order from a court or when public safety or order requires otherwise, as prescribed by law. Any violation of this provision renders the evidence obtained inadmissible for any purpose in any proceeding. The intimacies between husband and wife do not justify any one of them in breaking the drawers and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person, by contracting marriage, does not shed his or her integrity or his right to privacy. As an individual, and the constitutional protection is ever available to him or to her. The law ensures absolute freedom of communication between the spouses by making it privileged. Neither husband nor wife may testify for or against the other without the consent of the affected spouse while the marriage subsists. Neither may be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, save for specified exceptions. But one thing is freedom of information. Quite another is a compulsion for each one to share what one knows with the other. And this has nothing to do with the duty of fidelity that each owes to the other. The next case is the case of Morfe versus Motot. And it is a case that highlights privacy of communications. The facts of the case are as follows. One of the specific provisions of the Anti Graft and Corrupt Practices Act of 1960 is that every public officer, either within 30 days after its approval or after his assumption of office, and within the month of January of every other year thereafter, as well as upon termination of his position, shall prepare and file with the head of the office to which he belongs a true, detailed, and sworn statement of assets and liabilities, including a statement of the amounts and sources of his income, the amounts of his personal and family expenses, and the amount of income taxes paid for the preceding calendar. In relation to Morphe's alleged accumulation of assets grossly disproportionate to his reported incomes after his assumption to office, plaintiff Morpheus alleged that the periodical submission of such sworn statement of assets is violative of due process as an oppressive exercise of police power, and as an all and as an unlawful invasion and is an unlawful invasion of the constitutional right to privacy, implicit in the ban against unreasonable search and seizure, construed together with a prohibition against self incrimination. On the other hand, the defendant's Secretary of Justice and Executive Secretary contended that it was a legitimate exercise of police power, and that Morfe, having accepted a public position, voluntarily assumed the obligation to give information about his personal affair, not only at the time of his assumption of office, but during the time he continues to discharge public trust. The issue in this case is whether or not the required periodical submission of sworn statement of assets and liabilities is unconstitutional on the ground of it being an unlawful invasion of right to privacy and an insult to the personal integrity and official dignity of public officials. The ruling is no. The SC said, the Supreme Court said that such provision of Anti-Graft and Corrupt Practices Act is constitutional because such is within the state's police power and is not violative of due process and liberty. It is also not a violation of guarantee against unreasonable search and seizure and is not against the incrimination clause, the non-incrimination clause. Furthermore, it is not an insult to the personal integrity and official dignity of public officials. The Anti-Graft Act of 1960 was precisely aimed at curtailing and minimizing the opportunities for official corruption and maintaining a standard of honesty in the public service. It is intended to further promote morality in public administration. A public office must indeed be a public trust. The state's inherent police power enables it to prohibit all things hurtful to the comfort, safety, and welfare of society. However, if the police power extends to regulatory action affecting persons in public or private life, then anyone with an alleged grievance can invoke the protection of due process, which permits deprivation of property or liberty as long as such requirement is observed. If due process mandate is not disregarded, even a public official to protect the security of tenure, which is analogous to property, can protect himself from the infringement of his liberty. However, liberty in the interest of public health, public order, or safety of general welfare, in other words, through the proper exercise of the police power, may be regulated. In here, the reasonableness of the law makes the prohibition valid and within the ambit of police power. It would be to dwell in the realm of abstractions and to ignore the harsh and compelling realities of public service with its ever present temptation to heed the call of greed and avarice, to condemn as arbitrary and oppressive a requirement as that imposed upon public officials and employees to file such sworn statements of assets and liabilities every 2 years after having done so upon assuming office. There was therefore no unconstitutional exercise of police power. Furthermore, a periodical submission of sworn statements of assets and liabilities after assumption of office is within the power of the government to impose, even if it will affect the public officer's liberty, for as long as due process is observed in subjecting the public officer to such a further compulsory revelation of his assets and liabilities, including the statement of the amounts and sources of income, the amounts of personal and family expenses, and the amount of income taxes paid for the next preceding calendar year. There is no unconstitutional intrusion into what otherwise would be our private sphere. The next case is the case of Gingging versus Court of Appeals, and it is under freedom of expression. In this case, Circe Choi Toralba is a broadcast journalist with two radio programs airing in Visayas and Mindanao. Filed a criminal complaint for libel against Segundo Lim and petitioner Gingging for causing the publication of records of his criminal cases as well as photographs of his arrest. The criminal records and photos were published by means of a one-page advertisement paid for by Lim in the Sunday Post, a weekly publication edited and published by petitioner. Choi Toralba asserted that he has been acquitted and that the cases referred to in the publication had already been settled. He sought the conviction of Lim and Gingging for libel and claims that such publication placed him in public contempt and ridicule and was designed to degrade and malign his person and destroy him as a broadcast journalist. The trial court and the Court of Appeals found the publication indeed libelous, declaring that malice, the most important element of libel, was present in the case. In this case, every defamatory publication prima facie implies malice on the part of the author and publisher towards the person subject thereof. Lim, in his defense, claimed that the complainant was allegedly making scurrilous attacks against him, as well as his family, over the airwaves. Since Lim had no access to radio time, he opted for paid advertisements via newspaper to answer the attacks as a measure of self-defense. Lim also argued that complainant as a media man and member of the Fourth Estate occupied a position almost similar to a public functionary and should not be onion skinned and be able to absorb the thrust of public scrutiny. The lower court also ruled that publication of calumny, even against public officers or candidates for public office, according to the trial court, is an offense most dangerous to the people. It deserves punishment because the latter may be deceived thereby and reject the best and deserving citizens to their great injury. Thus, petitioner prayed for reversal of the judgment against him, contending that his conviction by the lower courts constitutes an infringement of his constitutional right to freedom of speech and of the press. The issue is whether or not the publication in the instant case is indeed libelous. The ruling states that under the law, criminal libel is defined as a public and malicious imputation of a crime, or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Thus, the elements of libel are imputation of a discreditable act or condition to another, B. Publication of the imputation, C. Identity of the person defamed, and lastly, existence of malice. However, in order to protect the constitutional guarantee of free speech, additional rules were applied to libel cases involving public figures. Originally, truth was not a de- truth was not a defense in criminal libel. There should be little controversy in holding that the complainant is a public figure. He is a broadcast journalist hosting two radio programs aired over a large portion of the Visayas and Mindanao. Complainant even asserted before the trial court that his broadcast was listened to widely, hence his notoriety is unquestionable. Complainant's standing as a public figure is further militated by the contextual circumstances of the case. The newspaper in question, the Sunday Post, is particularly in circulation in the areas where complainants' broadcasts were aired. Certainly, it cannot be denied that the target audience of the newspaper were the same persons who may have listened regularly to the complainant's broadcast. Even if the sphere of complainant's renown is limited in geography, it is in the same plane as the circulation of the offending newspaper. The extent of complainant's ability to influence hearts and minds through his broadcast need not be established. Only that he has such capacity and willingness to exert an influence. Complainant's volition to practice the radio broadcasting profession necessarily thrusts him in the public sphere. It should thus proceed that if the statements made against public figure are essentially true, then no conviction for libel can be had. Any statement that does not contain a provably false factual connotation will receive full constitutional protection. An examination of the records of this case showed that the presses of information contained in the questioned publication were actually true. It is clear that there was nothing untruthful about what was published in the Sunday Post. The criminal cases listed in the advertisement as pending against the complainant had indeed been filed. It may have been inconvenient for the complainant that these matters may have been divulged, yet such information hardly falls within any realm of privacy complainant could invoke. Since the pendency of these criminal charges are actually matters of public record. The information, moreover, went into the very character and integrity of complainant, to which his listening public as a very legitimate interest. Complainant hosts a public affairs program, one which he himself claimed was imbued with the public character since it deals with corruptions in government, corruptions by public officials, irregularities in government in comrades. By entering into his line of work, complainant in effect gave the public a legitimate interest in his life. He likewise gave them a stake in finding out if he himself had the integrity and character to have the right to criticize others for their conduct. A newspaper, especially one national in reach and coverage, should be free to report on events and developments in which the public has a legitimate interest with a minimum fear of being hauled to court by one group or another on criminal or civil charges for libel, so long as the newspaper respects and keep within the standards of morality and civility prevailing within the general community. To avoid self censorship that would necessarily accompany strict liability for erroneous statements, rules governing liability for injury to reputation are required to allow an adequate margin of error by protecting some inaccuracies. It is for the same reason that the New York Times doctrine requires that liability for defamation of a public official or public figure may not be imposed in the absence of proof. Absence of proof of actual malice on the part of the person making the libelous statement. To this end, the publication of the subject advertisement by petitioner and limb cannot be deemed by this court to have done with actual malice. Aside from the fact that the information contained in said publication was true, the intention to let the public know the character of their radio commentator can at best be subsumed under the mantle of having been done with good motives and for justifiable ends. The advertisement in question falls squarely within the bounds of constitutionally protected expression under Section 4, Article 3, and thus acquittal is mandated. The fifth case is the case of Tordesillas versus Honorable Ronaldo Puno, and it is under the subject of freedom of expression. The facts of the case are as follows. On November 29, 2007, now Senator Antonio Trillanes IV, Brigadier General Danilo Lim, and other members of the Magdalo Group walked out of the Regional Trial Court of Makati City before the sala of presiding judge Oscar Pimentel. During the hearing of their coup d'etat case, known as the Okud Mutiny, staged last July 2003, the group proceeded to the nearby Manila Peninsula Hotel, took over the hotel, and held a press conference at the lobby, calling for the ouster of then President Gloria Macapagal Arroyo. Members of the press, including some of the petitioners herein, proceeded to Manila Peninsula to cover the news on the said situation. Thereat, after issuing a statement at the lobby demanding for President Arroyo's ouster, the group moved to a function room. Members of the press then followed them to continue with their media coverage. Trillanes' group refused to receive the warrant issued by Judge Pimentel. The officers then shoved the warrant under the door and gave the group until 3 p.m. to vacate the premises. Despite the orders, Tordesillas and company opted to stay inside the function room with Trillanes' group. When the 3 o'clock deadline lapsed, the police authorities hurled tear gas canisters inside the hotel lobby and fired warning shots before breaking into the hotel to arrest Trillanes and his group. The members of the press who were inside the function room were also taken and brought to Camp Bagong Diwa with Trillanes' group. After processing, the said members of the press were cleared and released before midnight of the same day. Then DILG Secretary Ronaldo Puno stated that journalists who ignore police orders to leave a crime scene will be arrested and charged with obstruction of justice and willful disobedience of authority. This statement was backed by sentiments from the heads of the Armed Forces of the Philippines, Department of National Defense, Department of Justice, and the Philippine National Police. Then DOJ Secretary Raul Gonzalez issued an advisory to all media and press CEOs, which stated that their respective companies, networks, and organizations may incur criminal liabilities if any of their personnel disobey lawful orders from duly authorized government officers and personnel during emergencies which may lead to collateral damage to properties and civilian casualties in case of military or police operations. The then PNP Director General Avelino Razon announced his support to the said advisory of the DOJ Secretary. These circumstances prompted petitioners herein to file a complaint for damages and injunction with prayer for preliminary mandatory injunction and a technical restraining order against respondents. Petitioners averred that the warrantless and oppressive arrest of journalists who were peacefully exercising their constitutional rights clearly violates their right to press and project a chilling effect on such constitutionally protected freedom. Petitioners further averred that the acts complained of constitute prior restraint, as such acts prevented journalists from carrying out the duties of their profession to report on a matter of public interest. The issues of the case are first, whether or not the advisory issued by the respondents is is not content neutral and thus constitute prior restraint, censorship, and are content restrictive, which resulted to a chilling effect in violation of the freedom of the press. Second, whether or not the journalist's arrest was plain censorship. The ruling is no. There is prior concern there is prior restraint when the government totally prohibits and or in some way restricts the expression of one's view or the manner of expressing oneself. In this case, there is none. The challenged government actions in the instant petition do not in any way come near the government actions struck down as unconstitutional for being tantamount to a prior restraint or censorship. A plain reading of the questioned advisory clearly shows that no media network or personnel is prohibited nor restricted from reporting or writing on any subject matter, from being present and covering newsworthy events. Unlike the advisories or resolutions, subject of the cases above stated, the respondents' question acts never hindered the members of the press from freely exercising their profession to cover any newsworthy events such as the Manila Peninsula standoff. No form of threat can be deduced from the subject advisory. The advisory does not have any statements expressly or nor impliedly preventing the media to cover police operations and events relating to the Manila Peninsula standoff and to any future newsworthy events. Neither was there any indication of the claimed chilling effect on the exercise by the media of the right to free speech and press. It is of public knowledge that news and commentaries as regards the incident continued to be disseminated thereafter. There was no allegation, much less proof, that the media opted to step back from or refused to cover similar events due to fear of incurring criminal liability pursuant to the challenge advisory. Moreover, it should also be emphasized that the issuance of the advisory, as well as respondents' actions in ordering the dispersal of the media when the warrant of arrest was served, especially when Trillanes' group refused to receive the same, were valid exercises of the respondents' authorities according to RA 6975. The challenge advisory was merely a reminder of already established laws and jurisprudence, and the respondents' actions were lawful. With or without such advisory, if media networks and personnel are found to have violated penal laws, they may be prosecuted and held liable thereof. Hence, it cannot be said that the advisory and respondents' acts produced a chilling effect on the media's exercise of their profession. The sacrosanct freedom of expression and of the press does not entail unfettered access to information. Restrictions on the right of access to particular places at particular times are consistent with other reasonable restrictions on liberty based upon the police power, and these restrictions remain valid even though the ability of the press to gather news and express views on a particular subject may incidentally hampered, may be incidentally hampered. The ruling for the second issue is that there is no indication, much less proof, of a chilling effect or violation of petitioner's right to free speech or free press due to the taking of certain media personnel who refused to heed the order to vacate the premises during the arrest of the Trillanes group to Camp Bagong Diwa for processing, debriefing, and documentation. There's no prior restraint nor an impermissible regulation on the petitioner's freedom of speech and of the press, considering that respondents' questioned acts were merely brought about by the exigencies of the situation and ultimately were valid exercise of their authority, so as not to compromise the safety of the civilians at the scene of the incident. Indeed, a particular assessment of the particular circumstance on hand would show the necessity of respondents' actions. It is not unreasonable for the authorities to anticipate and deter a possible mayhem in the arrest of enraged military men who openly refused to succumb to the authorities and thus act upon the substantive interests of the state on public safety and order. So here are the summaries of each case. In the first case, People versus O'Coughlin, the summary is that although an airport screening search is sustained as a constitutionally reasonable administrative search, it is only constitutional when it is limited in the scope of the anti-hijacking program and not the war on illegal drugs. Also, the constitutional immunity against unreasonable searches and seizures is a personal right which may be waived. A person may voluntarily consent to have government officials conduct a search or seizure that would otherwise be barred by the Constitution. In the second case, Zulueta versus Court of Appeals, the intimacies between husband and wife do not justify any one of them in breaking the drawers and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person by contracting marriage does not shed his or her right or his or her integrity or his right to privacy as an individual, and the constitutional protection is ever available to him or to her. In the third case, Morphe versus Mutok, the challenged statutory provision does not call for disclosure of information which infringes on the right of a person to privacy. It cannot be denied that the rational relationship such a requirement possesses with the objective of a valid statute goes very far in precluding assent to an objection of such character. It is not to say that a public officer, by virtue of the position he holds, is bereft of constitutional protection. It is only to emphasize that in subjecting him to such a further compulsory revelation of his assets and liabilities, including the statement of the amounts and sources of income, the amounts of personal and family expenses, and the amount of income taxes paid for the next preceding calendar year, there is no unconstitutional intrusion into what would otherwise be a private sphere. For the fourth case, Gingging versus Court of Appeals, it was held that by entering into a line of work which is public in nature or allows you to be a public figure, the complainant, in effect, gave the public a legitimate interest in his life. He likewise gave them a stake in finding out if he himself had the integrity and character to have the right to criticize others for their conduct. It should thus proceed that if the statements made against a public figure are essentially true, then no conviction for libel can be had. Any statement that does not contain a provably false factual connotation will receive full constitutional protection. And for the case of Tordesillas versus Honorable Ronaldo Puno, it states that the sacrosanct freedom of expression and of the press does not entail unfettered access to information. Restrictions on the right of access to particular places at particular times are consistent with other reasonable restrictions on liberty based upon the police power, and these restrictions remain valid even though the ability of the press to gather news and express views on a particular subject may be incidentally hampered.
Good day, attorney. Good day, classmates. I'm the next reporter, Jacob Soares, and I will be reporting about the following cases, which tackles about freedom of expression and freedom of religion under the Bill of Rights of our Constitution. So here's a preview of the first case, which is Zaldivar versus Gonzalez. So in this case, Gonzalez cannot invoke freedom of speech as a defense Apart from being a lawyer and an officer of the court, he is also a special prosecutor who owes duties of fidelity and respect to the Republic and to the Supreme Court. Zaldivar has asserted that the court was preventing him from prosecuting rich and powerful persons, that the court was in effect discrimination between the rich and powerful on the one hand and the poor and defenseless upon the other, and allowing the rich and powerful accused persons to go scot-free, while presumably allowing or affirming the conviction of poor and small offenders. So here are the facts of the case. Zaldivar was the governor of Antique and was charged before the Sandigan Bayan for violations of the Anti-Graft and Corrupt Practices Act. Gonzales Gonzales was then the Tanod Bayan who was investigating the case. Zaldivar then filed with the Supreme Court a petition for certiorari, prohibition and mandamus, assailing the authority of the Tanod Bayan to investigate graft cases under the 1987 Constitution. The Supreme Court, acting on the petition, issued a cease and desist order against Gonzales, directing him to temporarily restrain from investigating and filing informations against Zaldivar. Gonzales, however, proceeded with the investigation and he filed criminal informations against Zaldivar. Respondent Gonzales has also asserted that the court was preventing him from prosecuting the rich and powerful persons, that the court was in effect discrimination between the rich and the powerful on one hand and the poor and defenseless upon the other, and allowing the rich and powerful accused persons to go scot-free, while presumably allowing or affirming the conviction of poor and small offenders. So the issue in this case, or whether or not respondent attorney Gonzales is entitled to invoke freedom of speech as his defense. So the ruling of the Supreme Court is no, since respondent indefinitely was suspended from the practice of law. His statements necessarily imply that the justices of the Supreme Court betrayed their oath of office. Such statements very clearly debase and degrade the Supreme Court, and through the court, the entire system of administration of justice in the country. Gonzales is entitled to the constitutional guarantee of free speech. When Gonzales seems unaware of his that expression, like all constitutional freedoms, is not absolute, and that freedom of expression needs on occasion to be adjusted to and accommodated with the requirements of equally important public interests. One of the fundamental public interests is the maintenance of the integrity and orderly functioning of the administration of justice. There is no antinomy, there is no antinomy between free expression and the integrity of the system of administering justice. Gonzales, apart from being a lawyer and an officer of the court, is also a special prosecutor who owes duties of fidelity and respect to the Republic of the Supreme Court as the embodiment and the repository of the judicial power and the government of the Republic. The responsibility of Gonzales to uphold the dignity and authority of the Supreme Court and not to promote distrust in the administration of justice is heavier than that of a private practicing lawyer. Gonzales is also entitled to criticize the rulings of the court, but his criticisms must be bona fide. In the case at bar, his statements, particularly the one where he alleged that members of the Supreme Court approached him, are of no relation to the Zaldivar case. The court concludes that the respondent is guilty both of contempt of court in facie cure and of gross misconduct as an officer of the court and member of the bar. So for the next case, it's GMA Network Incorporated versus Comelec. It was decided on September 2, 2014. So for a quick preview of the case, The COMELEC Resolution Number 9615 on airtime limits violates freedom of expression, of speech, and of the press. The limiting of the broadcast and radio advertisements of candidates and political parties for national election positions to an aggregate total of 120 minutes and 180 minutes respectively. They contend that such restrictive regulation on allowable broadcast time violates freedom of the press, impairs the people's rights to suffrage, as well as their right to information relative to the exercise of their right to choose who to elect during the forthcoming elections. So here are the facts of the case. The five petitions before the court put in issue the alleged unconstitutionality of COMELEC Resolution Number 9615, Section 9, which limits the broadcast and radio advertisements of candidates and political parties for national election positions to 120 minutes and 180 minutes respectively. They contend that such restrictive regulations on allowable broadcast time violates freedom of the press, impairs people's right to suffrage as well as the right to information relative to the exercise of the right to vote or choose who to elect during the elections. Section 9 provides aggregate total airtime instead of the previous per station airtime for political campaigns or advertisements, and also required prior COMELEC approval for candidates' television and radio guesting appearances. So the issue in this case is whether or not Section 9 of COMELEC Resolution 9615 on airtime limits violates freedom of expression, of speech, and of the press. The court ruled that yes, it held that the assailed rule on aggregate-based airtime limits is unreasonable and arbitrary as it unduly restricts and constrains the ability of candidates and political parties to reach out and communicate with the people. Here, the adverted reason for imposing the aggregate-based airtime limits, leveling the playing field, does not constitute a compelling state interest which would justify such a substantial restriction on the freedom of candidates and political parties to communicate their ideas, philosophies, platforms, and programs of government. And this is especially so in the absence of a clear-cut basis for the imposition of such a prohibitive measure. It is also particularly unreasonable and whimsical to adopt the aggregate-based time limits on broadcast time when we consider that the Philippines is not only composed of so many islands, there are also a lot of languages and dialects spoken among the citizens across the country. Accordingly, for a national candidate to really reach out to many of the electorates as possible, then it might also be necessary that he conveys his message through his advertisements in languages and dialects that the people may more readily understand and relate to. To add, all of these airtimes in different dialects would greatly hamper the ability of such candidate to express himself, a form of suppression of his political speech. So for the next case, it's SWS versus Comelec, which was decided on May 5, 2001. So for a quick preview of the case, it tackles about the Fair Election Act, which tackles about surveys affecting national candidates shall not be published 15 days before an election, and surveys affecting local candidates shall not be published 7 days before an election. This constitutes an unconstitutional abridgment of freedom of speech, expression, and the press. It constitutes a prior restraint on the exercise of freedom of speech without any clear and present danger to justify such restraint. So here are the facts of the case. Petitioner brought this action for prohibition to enjoin the Commission on Elections from enforcing Section 5.4 of RA 9006 or the Fair Election Act, which provides that surveys shall not be published 15 days before an election and surveys affecting local candidates shall not be published 7 days before an election. Petitioner SWS states that it wishes to conduct an election survey throughout the period of the elections, both of the national and local levels, and release to the media the results of such survey, as well as publish them directly. Petitioner Kamahalan Publishing Corporation, on the other hand, states that it intends to publish election surveys result up to the last day of the elections on May 14, 2001. Petitioners argue that the restriction on the publication of survey results constitute a restraint on the exercise of freedom of speech without any clear and present danger to justify such restraint. They claim that SWS and other pollsters conducted and published the results of surveys prior to the previous elections up to as close as 2 days before the election day without causing confusion among the voters, and there is neither em- empirical nor historical evidence to support the conclusion that there is an immediate and an inevitable danger to tie voting process posed by election surveys. They point that no similar restriction is imposed on politicians from explaining their opinion or on newspapers or broadcast media from writing and publishing articles concerning political issues up to the day of the election. Consequently, they contend that there is no reason for ordinary voters to be denied access to the result of the election surveys, which are relatively objective. Respondent Commission on Elections justifies the restrictions as necessary to prevent the manipulation and corruption of the electoral process by unscrupulous and erroneous surveys just before the election. The following contentions are the prohibition on the publication of election survey results during the period prescribed by law bears a rational connection to the objective of the law. The prevention of the debasement of the electoral process resulting from manipulated surveys, bandwagon effect, and absence of reply. Second, it is narrowly tailored to meet the evils sought to be prevented, and the impairment of freedom of expression is minimal, the restriction being limited both in duration, the last 15 days, and 7 days for a local election, and in scope as it does not prohibit election survey results, but only require timeliness. So the issue in this case is whether or not COMELEC restriction on survey during the election period constitute a violation of the freedom of expression. The court held that yes, as as the United States Supreme Court through Chief Justice Warren held in U.S. versus O'Brien, a government regulation is sufficiently justified. Number one, if it is within the constitutional power of the government, if it furthers an important or substantial government interest, if the governmental interest is unrelated to the suppression of free expression, and if the incidental restriction on alleged First Amendment freedom of speech, expression, and press is no greater than is essential to the furtherance of that interest. This is so far as the most influential test for distinguishing content-based from content-neutral regulations, and is said to have become canonical in the review of such laws. It is noteworthy that the O'Brien test has been applied by this court in at least two cases. First, Section 5.4 fails to meet criterion of the O'Brien test because the casual connection of expression to the asserted governmental interest makes such interest not related to the suppression of free expression. By prohibiting publication of election survey results because of possibility that such publication might undermine the integrity of the election. The section actually suppresses a whole class of expression while allowing the expression of opinion concerning the same subject matter by newspaper columnists, radio and TV commentators, theorists, and other opinion takers, even if the governmental interest sought to be promoted is unrelated to the suppression of speech and the resulting restriction of free expression is only incidental, nonetheless fails to meet criterion of the O'Brien test, namely that the restriction be not greater than is necessary to further the governmental interest. As already stated, Section 5.4 aims at the prevention of last-minute pressure on voters, the creation of bandwagon effect, junking of weak or losing candidates, and resort to the form of election cheating called dagdag bawas. Praiseworthy as these aims of the regulation might be, they cannot be attained at the sacrifice of the fundamental right of expression when such aim can be more narrowly pursued by punishing unlawful acts rather than speech because of apprehension that such speech creates the danger of such evils. To summarize then, we hold that Section 5.4 is invalid because it imposes a prior restraint on the freedom of expression. It is a direct and total suppression of a category of expression even though such suppression is only for a limited period, and the governmental interest sought to be promoted can be achieved by means other than suppression of freedom of expression. The next case is Soriano versus People, which was decided on November 21, 2018. So for a quick preview, it tackles about for an imputation to be libelous, the following requisite must be present. It must be defamatory, it must be malicious, it must be given publicity, and the victim must be identifiable. In determining whether a statement is defamatory, the words used are to be construed in their entirety and should be taken in their plain, natural, and ordinary meaning as they would naturally be understood by persons reading them, unless it appears that they were used and understood in another sense. So for the facts of the case, petitioner Eliseo Soriano was indicted for libel. Information states the accused being then the anchorman of a religious radio program ang dating daan of DZAL at Iriga City with intent to cause and expose to public ridicule, dishonor, discredit, or contempt upon the persons comprising the Jesus Miracle Crusade International Ministry publicly aired his prepared tape broadcast containing false, injurious, and defamatory statement with no good intention or justifiable motive in the guise of preaching the gospel of the Lord by branding its leader as Bolaan Profeta, letter T, and letter G word, its pastors as pastor ng mga letter D and mga pastor na letter I and G, and its members as isang dakot na G and S. A similar information for libel was also filed against petitioner on a later date. After trial, the regional trial court found petitioner guilty of 2 counts of libel. The Court of Appeals affirmed RTC's decision. So the issue in this case, whether or not freedom of speech can be invoked and whether or not petitioner is guilty of libel. So the court ruled that yes, The Supreme Court said that libel under Article 353 under Article 353 of the Revised Penal Code is defined as a public and malicious imputation of a crime or of a vice or defect, real, imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. For an imputation to be libelous, the following requisites must be present. It must be defamatory, must be malicious, must be given publicity, and the victim must be identifiable. In determining whether a statement is defamatory, the words used are to be construed in their entirety and should be taken in their plain, natural, and ordinary meaning as they would naturally be understood by persons reading them, unless it appears that they were used and understood in another sense. Moreover, a charge is sufficient if the words are calculated to induce the hearers to suppose and understand that the person or persons against whom they were uttered were guilty of certain offenses or are sufficient to impeach the honesty, virtue, or reputation, or to hold the person or persons up to public ridicule. From the above-mentioned test, petitioner's words stated during the airing of his program are clearly defamatory and cannot invoke the freedom of speech. So for the next case, it's Peralta versus Philippine Postal Corp et al., which was decided on December 4, 2018. So, uh, so for a quick preview of the case, in this case, the printing of the INC Centennial commemorative stamps by the PPC does not undermine the freedom of religion. The stamps were neither for the benefit of INC nor money derived from their sale inured to its benefits. The stamp delivered to INC were not free of charge, and whatever income derived from the sale to INC and of the excess to the postal clients were not given to the INC, but went to the coffers of Philpost. So for the facts of the case, on May 10, 2014, respondent PPC Philpost issued a stamp commemorating Iglesia ni Cristo's centennial celebration. Mr. Peralta filed a complaint assailing the constitutionality of the printing, issuance, and distribution of the INC commemorative centennial stamps, allegedly paid for by respondent Philpost using public funds. He argued that the respondent's act of releasing the said stamps was unconstitutional because it was tantamount to sponsorship of a religious activity. It violated the separation of the church and the state and the non-establishment of religion clause. So the issue in this case is, did the printing of the INC Centennial commemorative stamps by the PPC undermine freedom of religion? The court ruled that no, the printing and issuance of the assailed commemorative stamps were not inspired by any sectarian denomination. The court finds no reason or basis to grant the petition in refusing to declare unconstitutional the INC's commemorative stamp. So let's have a quick recap on the cases tackling about freedom of expression and freedom of religion. So in Zaldivier versus Gonzalez, Gonzalez cannot invoke freedom of speech as a defense. Apart from being a lawyer and an officer of a court, he is also a special prosecutor who owes duties of fidelity and respect to the Republic and to Supreme Court. His statement saying rich and powerful persons, that the court was in effect discrimination between the rich and powerful on one hand and the poor and defenseless upon the other, and allowing rich and powerful accused persons to go scot-free while presumably allowing or affirming the conviction of poor and small offenders, doesn't count as freedom of expression as stated by the Supreme Court. In GMA Network Incorporated versus Comelec, limiting the broadcast and radio advertisements of candidates to 120 and 180 minutes respectively violates freedom of the press, as it impairs the people's right to suffrage as well as the right to information relative to the exercise of the right to choose who to elect during the forthcoming elections. In SWS versus Comelec, it was held that the surveys affecting national candidates shall not be published within 15 days before an election, and surveys affecting local candidates shall not be published 7 days before an election. This constitutes an unconstitutional abridgment of freedom of speech, expression, and press. It constitutes a prior restraint on the exercise of freedom of speech without any clear and present danger to justify such restraint. In versus People, it mentioned that for an imputation to be libelous, the following must be present: it must be defamatory, it must be malicious, it must be given publicity, and the victim must be identifiable. In determining whether a statement is defamatory, the words used are to be construed in their entirety and should be taken in their plain, natural, and ordinary meaning, as they would naturally be understood by persons reading them, unless it appears that they were used and understood in another sense. So if the following requisites are present, such will not constitute freedom of speech. And lastly, in Peralta versus Philippine Postal Corporation, it held that the printing of the INC Centennial commemorative stamps by the PPC does not undermine the freedom of religion. The stamps were neither for the benefit of INC nor money derived from their sale inured to its benefits. The stamp delivered to INC were not free of charge, and whatever income derived from the sale to INC and of the excess to the postal clients were not given to INC but went to the coffers of PhilPost.
Good day. I'm Andrea Tizona, the third reporter of Group 6. I will be discussing cases under the following topics: freedom of religion, liberty of abode and travel, and non-impairment of contracts. The first case is the letter of Tony Valenciano holding religious rituals at the Hall of Justice building in Quezon City under the topic of freedom of religion. The facts of this case are as follows. Tony Valenciano wrote a series of letters addressed to then Chief Justice Reynato Puno. In his first letter, Valenciano reported that the basement of the Hall of Justice of QC had been converted into a Roman Catholic chapel, complete with offertory table, images of Catholic religious icons, a canopy, and a projector. He believed that such practice violated the constitutional provision on the separation of church and state and the constitutional prohibition against the appropriation of public money or property for the benefit of a sect, church, denomination, or any other system of religion. He also averred that the holding of masses at the basement of the QC Hall of Justice showed that it tended to favor Catholic litigants. He also averred that the employees and litigants in the Hall of Justice would not go to the lavatories because they could not traverse the basement between 12 o'clock p.m. and 1:15 p.m. Lastly, that the water supply in the entire building was cut off during the mass because the generator was turned off to ensure silence. Valenciano's letter was then referred to Judge Bay of the RTC and to Judge Masarin of the METC for their respective comments. Judge Masarin clarified that the basement of the QC Hall of Justice was known as the prayer corner, and the use of the said area for holding masses did not violate the constitutional prohibition against the use of public property for religious purposes, because the religious character of such use was merely incidental to a temporary use. On the other hand, Judge Bay recommended that daily masses are permitted, provided that the inconveniences of the mass be addressed. Valenciano soon wrote another letter praying that rules be promulgated by the court to put a stop to the holding of religious rituals at the QC Hall of Justice and in all other halls of justice in the country. The court noted this letter and referred the matter to the Office of the Court Administrator, or the OCA, for evaluation, report, and recommendation. In turn, the OCA referred the letters of Valenciano to the incumbent RTC Executive Judge Fernando Sagon Jr. and incumbent METC Executive Judge Caridad Walls Duterte. In their respective letters, both Judge Sagon Jr. and Judge Lotero reported, among others, that they had already implemented measures to address Valenciano's complaints, that the basement of the QC Hall of Justice could still be used as waiting area for the public, and that the court employees prepared for the mass before the day officially started, so that the performance of their official duties in court was not hampered. In dismissing the letter complaints, the OCA believed that the practical inconveniences cited by Valenciano were unfounded. The OCA advanced the view that the standard of benevolent neutrality or accommodation was espoused because the principal religion clauses in our Constitution were not limited to the Establishment Clause, which created a wall between the church and state, but was quickly followed by the declaration of the Free Exercise Clause, which protected the right of the people to practice their religion. In effect, the standard of benevolent neutrality or accommodation balanced the interest of the state through the Establishment Clause, and the interest and right of the individual to freely exercise his religion as guaranteed by the Free Exercise Clause. The OCA observed that the present controversy did not involve a national or local law or regulation in conflict with the Free Exercise Clause. On the contrary, Valenciano was merely questioning the propriety of holding religious masses at the basement of the QC Hall of Justice, which was nothing more than an issue of whether the said religious practice could be accommodated or not. There are three issues in this case. First, whether or not the holding of religious rituals in the halls of justice violates the constitutional provision on the separation of church and state. Second is whether the holding of Catholic masses at the basement of the QC Hall of Justice is a case of establishment or a case of accommodation. And the third issue is whether or not the holding of religious rituals in the halls of justice violates the constitutional prohibition against the appropriation of public money or property for the benefit of a sect, church, denomination, or any other system of religion. As to the first issue, the court ruled in the negative. Indeed, Section 6, Article 2 of the Constitution provides that the separation of church and state shall be inviolable. Justice Cruz explained that the idea is to delineate the boundaries between the two institutions and avoid encroachments by one against the other because of a misunderstanding of the limits of their respective exclusive jurisdictions. The demarcation line calls on the entities to render therefore unto Caesar the things that are Caesar's, and unto God the things that are God's. This notwithstanding, the state still recognizes the inherent right of the people to have some form of belief system, whether such may be belief in a supreme being, a certain way of life, or even an outright rejection of religion. Thus, the right to believe or not to believe has again been enshrined in Section 5, Article 3 of the 1987 Constitution. It provides that The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. The court also stated that the right to religious profession and worship has a twofold aspect: freedom to believe and freedom to act on one's beliefs. The first is absolute as long as the belief is confined within the realm of thought. The second is subject to regulation, where the belief is translated into external acts that affect the public welfare. The court further noted that allowing religion to flourish is not contrary to the principle of separation of church and state. In fact, these two principles are in perfect harmony with each other. As pointed out by Judge Litero, the Roman Catholics express their worship through the Holy Mass, and to stop these would be tantamount to repressing the right to the free exercise of their religion. Clearly, allowing the citizens to practice their religion is not equivalent to a fusion of church and state. Religious freedom, however, is not absolute. It cannot have its way if there is a compelling state interest. To successfully invoke compelling state interest, it must be demonstrated that the masses in the QC Hall of Justice unduly disrupt the delivery of public services or affect the judges and employees in the performance of their official functions. In Estrada versus Escritor, the court stated that the compelling state interest test is proper where conduct is involved for the whole gamut of human conduct has different effects on the state's interests. However, not any interest of the state would suffice to prevail over the right to religious freedom, as this is a fundamental right that enjoys a preferred position in the hierarchy of rights, the most inalienable and sacred of all human rights. Only the gravest abuses endangering paramount interests can limit this fundamental right. A mere balancing of interests, which balances a right with just a colorable state interest, is therefore not appropriate. Instead, only a compelling interest of the state can prevail over the fundamental right to religious liberty. The test requires the state to carry a heavy burden, a compelling one, for to do otherwise would allow the state to batter religion, especially the less powerful ones, until they are destroyed. In determining which shall prevail between the state's interest and religious liberty, reasonableness shall be the guide. As reported by the executive judges of QC, the masses were being conducted only during noon breaks and were not disruptive of public services. Moreover, no civil service rules were being violated. As there had been no detrimental effect on the public service or prejudice to the state, there is simply no state interest compelling enough to prohibit the exercise of religious freedom in the halls of justice. Hence, the holding of religious rituals in the halls of justice does not violate the constitutional provision on the separation of church and state. As to the second issue, the court ruled that the holding of Catholic masses at the basement of the QC Hall of Justice is not a case of establishment, but merely accommodation. In ruling the same, the court first distinguished accommodation from establishment. Accommodation is a recognition of the reality that some governmental measures may not be imposed on a certain portion of the population for the reason that these measures are contrary to their religious beliefs. As long as it can be shown that the exercise of the right does not impair the public welfare, the attempt of the state to regulate or prohibit such right would be an unconstitutional encroachment. In Estrada versus Escritor, the court adopted a policy of benevolent neutrality. Further, several laws have been enacted to accommodate religion. An example of which is Presidential Decree Number 1083, which allows a Filipino Muslim to have more than one wife and exempts him from the crime of bigamy that is punishable under the RPC. On the opposite side of the spectrum is the constitutional mandate that no law shall be made respecting an establishment of religion otherwise known as a non-establishment clause. It means that the state cannot set up a church, nor pass laws which aid one religion, aid all religion, or prefer one religion over another, nor force nor influence a person to go to or remain away from church against his will, or force him to profess a belief or disbelief in any religion. Its minimal sense is that the state cannot establish or sponsor an official religion. In the same breath, the Establishment Clause restricts what the government can do with religion. It also limits what religious sects can or cannot do. They can neither cause the government to adopt their particular doctrines as policy for everyone, nor can they cause the government to restrict other groups. To do so would cause the state to adhere to a particular religion and thus establish a state religion. Establishment entails a positive action on the part of the state. Accommodation, on the other hand, is passive. In the former, the state becomes involved through the use of government resources with the primary intention of setting up a state religion. In the latter, the state, without being entangled, merely gives consideration to its citizens who want to freely exercise their religion. Guided by the foregoing, the court ruled that the holding of the Catholic Masses at the basement of the QC Hall of Justice is not a case of establishment, but merely accommodation, and has laid down 5 main points. First, there is no law, ordinance, or circular issued by any duly constituted authorities expressly mandating that judiciary employees attend the Catholic Masses at the basement. Second, when judiciary employees attend the Masses to profess their faith, it is at their own initiative as they are there on their own free will and volition, without any coercion from the judges or administrative officers. Third, no government funds are being spent because the lightings and air conditioning continue to be operational, even if there are no religious rituals there. Fourth, the basement has neither been converted into a Roman Catholic chapel, nor has it been permanently appropriated for the exclusive use of its faithful. Fifth, the allowance of the Masses has not prejudiced other religions. Hence, the holding of Catholic Masses at the basement of the QC Hall of Justice is merely a case of accommodation. As to the third issue, the court ruled in the negative. The holding of religious rituals in the halls of justice does not violate the constitutional prohibition against the appropriation of public money or property for the benefit of a sect, church, denomination, or any other system of religion. Section 29, paragraph 2 of Article 6 of the 1987 Constitution provides, no public money or property shall be appropriated, applied, paid, or employed, directly or indirectly, for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. The court proceeded to emphasize the meaning of certain words in the said provision. The words pay and employ should be understood to mean that what is prohibited is the use of public money or property for the sole purpose of benefiting or supporting any church. The prohibition contemplates a scenario where the appropriation is primarily intended for the furtherance of a particular church. It has also been held that the aforecited constitutional provision does not inhibit the use of public property for religious purposes, when the religious character of such use is merely incidental to a temporary use, which is available indiscriminately to the public in general. In relation thereto, the phrase directly or indirectly refers to the manner of appropriation of public money or property, not as to whether a particular act involves a direct or a mere incidental benefit to any church. The Constitution is to be interpreted as a whole. As such, the foregoing interpretation finds support in the Establishment Clause, which is clear in stating that what is prescribed is the passage of any law which tends to establish a religion, not merely to accommodate the free exercise thereof. Here, the basement of the QC Hall of Justice is not appropriated, applied, or employed for the sole purpose of supporting the Roman Catholics. Further, it has not been converted into a Roman Catholic chapel for the exclusive use of its faithful, contrary to the claim of Valenciano. George Sagun related that masses run for just a little over 30 minutes. It is therefore clear that no undue religious bias is being committed when the subject basement is allowed to be temporarily used by the Catholics to celebrate Mass, as the same area can be used by other groups of people and for other purposes. The basement of the QC Hall of Justice has remained to be a public property devoted for public use because the holding of Catholic Masses therein is a mere incidental consequence of its primary purpose. Hence, the holding of religious rituals in the halls of justice does not violate the constitutional prohibition against the appropriation of public money or property for the benefit of a sect, church, denomination, or any other system of religion. We now move on to the second case, Soriano versus People, under the topic of freedom of religion. The facts of this case are as follows. Petitioner Eliseo Soriano appeals through a petition for review on certiorari under Rule 45 of the Rules of Court, the decision and resolution of the Court of Appeals, which affirmed the decision of the Iriga RTC, convicting petitioner of 2 counts of libel. Informations were filed against Petitioner Soriano charging him with libel. It was alleged therein that Soriano publicly aired in his said radio program his state broadcast containing false, injurious, and defamatory statements against persons comprising the Jesus Miracle Crusade International Ministry and evangelist Will Almeida. Upon arraignment, petitioner pleaded not guilty to the criminal charges, and after trial, the RTC found petitioner guilty of 2 counts of libel. On appeal, the CA affirmed the ruling of the RTC. In this petition for review on certiorari, petitioner argues that the CA committed reversible error when its decision effectively curtails and creates chilling effect on the constitutionally guaranteed right of freedom of expression. Specifically, petitioner claims that his statements are absolutely protected by the Constitution because they are expressions of religious beliefs. The issue in this case is whether or not Petitioner Soriano's statements are absolutely protected by the Constitution because they are expressions of religious beliefs. The court ruled in the negative. Petitioners claim that his statements are absolutely protected by the Constitution because they are expressions of religious beliefs do not merit any consideration. The court has previously held that plain and simple insults directed at another person cannot be elevated to the status of religious speech. The words used by Soriano in his statements are malicious in themselves. While the court affirmed petitioner's guilt of libel, the court clarified that petitioner's guilt stems from his statements against Pastor Almeida and not the JMCIM or any of its pastors. The court also noted that aside from mentioning Almeida's name, petitioner's statements did not refer to any specific pastor or member of the JMCIM. The third case is the consolidated cases of Genuino versus De Lima et al. And Macapagal Arroyo versus De Lima et al. Under the topic of liberty of abode and travel. The facts are as follows. In 2010, then acting DOJ Secretary Alberto Agra issued the assailed DOJ Circular Number 41, consolidating DOJ Circular Numbers 17 and 18, which will govern the issuance and implementation of whole departure orders, watchlist orders, and allow departure orders. The circular provides for the power of the DOJ Secretary to issue a watchlist order against persons with criminal cases pending preliminary investigation or petition for review before the DOJ. It also states that the DOJ Secretary may issue an allow departure order to a person subject of a watchlist order who intends to leave the country for some exceptional reasons. After the expiration of Gloria Macapagal Arroyo's term as President of the Philippines, criminal complaints were filed against her before the DOJ. Because of these complaints, Secretary De Lima issued a DOJ watchlist order pursuant to her authority under DOJ Circular Number 41. GMA then filed the present petition for certiorari and prohibition under Rule 65 to annul and set aside DOJ Circular Number 41 and watchlist orders issued against her for allegedly being unconstitutional for violating the constitutional guarantee of the right to travel. Thereafter, Miguel Arroyo filed a separate petition for certiorari and prohibition under Rule 65, likewise assailing the constitutionality of DOJ Circular Number 41. Similarly, petitioners Efraim Genuino, Erwin Genuino, and Cheryl Genuino C., or the Genuinos, pray for the nullification of the whole departure order issued against them. The HDO was issued against the Genuinos after criminal complaints for various charges were filed against them. The court later consolidated the said petitions assailing the constitutionality of DOJ Circular Number 41, Series of 2010. There are two issues in this case. First, whether or not DOJ Circular Number 41 is constitutional insofar as the authority of the DOJ Secretary to issue HDOs is concerned. The second is whether or not the DOJ has the inherent power to issue HDOs or restrict the right to travel in any way. As to the first issue, the court ruled in the negative. To begin with, there is no law particularly providing for the authority of the Secretary of Justice to curtail the exercise of the right to travel in the interest of national security, public safety, or public health. As it is, the only ground of the former DOJ Secretary in sustaining the petitioners at that time was the pendency of the preliminary investigation of the joint DOJ-COMELEC Preliminary Investigation Committee on the complaint for electoral sabotage against them. To be clear, DOJ Circular Number 41 is not a law. It is a mere administrative issuance apparently designed to carry out the provisions of an enabling law which the former DOJ Secretary believed to be EO number 292 or the Administrative Code of 1987. De Lima opined that DOJ Circular Number 41 was validly issued pursuant to the agency's rulemaking powers provided in Sections 1 and 3, Book 4, Title 3, Chapter 1 of EO number 292 and Section 50, Chapter 11, Book 4 of the mentioned code. An examination of the provisions being relied upon by the former DOJ Secretary will disclose that they do not particularly vest the DOJ the authority to issue DOJ Circular Number 41, which effectively restricts the right to travel through the issuance of watchlist orders and whole departure orders. To be specific, Section 1 is simply a declaration of policy, the essence of the law which provides for the statement of the guiding principle, the purpose, and the necessity for the enact. In the same way, Section 3 does not authorize the DOJ to issue WLOs and HDOs to restrict the constitutional right to travel. There is even no mention of the exigencies stated in the Constitution that will justify the impairment. The provision simply grants the DOJ the power to investigate the commission of crimes and prosecute offenders, which are basically the functions of the agency. However, it does not carry with it the power to indiscriminately devise all means it deems proper in performing its functions without regard to constitutionally protected rights. The curtailment of a fundamental right, which is what DOJ Circular Number 41 does, cannot be read into the mentioned provision of the law. Any impairment or restriction in the exercise of a constitutional right must be clear, categorical, and unambiguous. As such, it is a compulsory requirement that there be an existing law, complete and sufficient in itself, conferring the express authority to the concerned agency to promulgate rules. On its own, the DOJ cannot make rules, its authority being confined to execution of laws. Consistent with the foregoing, there must be an enabling law from which DOJ Circular Number 41 must derive its life. Unfortunately, the DOJ miserably failed to establish the existence of the enabling law that will justify the issuance of the questioned circular. It bears emphasizing that the conduct of a preliminary investigation is an implement of due process, which essentially benefits the accused, as it accords an opportunity for the presentation of his side with regard to the accusation. The accused may, however, opt to waive his presence in the preliminary investigation. The DOJ, therefore, cannot justify the restraint in the liberty of movement imposed by DOJ Circular Number 41 on the ground that it is necessary to ensure presence and attendance in the preliminary investigation of the complaints. Hence, DOJ Circular Number 41 is unconstitutional. As to the second issue, the court ruled in the negative. The DOJ has no inherent power to issue HDOs or restrict the right to travel in any way. The DOJ argues that Section 6, Article 3 of the Constitution is not an exclusive enumeration of the instances wherein the right to travel may be validly impaired. It cites that this court has its own administrative issuances restricting travel of its employees, and that even lower courts may issue HDOs even on grounds outside of what is stated in the Constitution. The argument fails to persuade. The power to issue HDO is inherent to the courts. The court may issue an HDO against an accused in a criminal case so that he may be dealt with in accordance with law. It does not require legislative conferment or constitutional recognition. It coexists with the grant of judicial power. As regards the power of the courts to regulate foreign travels, the court has explained that with respect to the power of the court, Section 5, Paragraph 6, Article 8 of the 1987 Constitution provides that the Supreme Court shall have administrative supervision over all courts and the personnel thereof. It is therefore by virtue of its administrative supervision over all courts and personnel that this court came out with an OCA circular which provided for the guidelines that must be observed by employees of the judiciary seeking to travel abroad. This is to ensure management of court dockets and to avoid disruption in the administration of justice. The same can be said of the regulations of the CSC with respect to the requirement for leave application of employees in the government service seeking to travel abroad. The objective was clearly administrative efficiency so that government employees will continue to render public services unless they are given approval to take a leave of absence, in which case they can freely exercise their right to travel. The point is that the DOJ may not justify its imposition of restriction on the right to travel of the subjects of DOJ Circular Number 41 by resorting to an analogy. Hence, contrary to its claim, it does not have the inherent power to issue HDO, unlike the courts, or to restrict the right to travel in any way. It is limited to the powers expressly granted to it by law, and may not extend the same on its own accord, or by any skewed interpretation of its authority. The next case is the case of Garcia versus Sandigan Bayan et al. Under the topic of liberty of abode and travel. The facts are as follows. On July 19, 2012, informations charging petitioner Gwendolyn Garcia, among others, for violation of Sections 3E and 3G of RA number 3019 and Article 220 of the RPC were filed before the Sandigan Bayan. Subsequently, Sandigan Bayan issued 3 HDOs against the petitioner and her co-accused. In the meantime, the petitioner voluntarily surrendered to Judge Soliver Peras and made 3 separate cash deposits of 30,000 pesos as bail for her provisional liberty corresponding to the 3 cases filed against her. Accordingly, Judge Perez issued 3 separate orders of release. The petitioner then filed a motion for leave to file motion for reconsideration with the Ombudsman with motion for suspension of proceedings. After hearing the motion, the Sandigan Bayan issued an order holding in abeyance further proceedings in the cases with respect to the petitioner and ordering the Ombudsman to take cognizance of the motion for reconsideration she filed before the said office. Thereafter, the petitioner received a notice of HDO along with 3 HDOs issued against her. She then filed a motion for reconsideration arguing that the HDOs cannot be issued without a final determination of probable cause. She claimed that the HDOs were violative of her constitutional right to travel, which may be impaired only in the interest of national security, public safety, or public health as may be provided by law. For its part, the prosecution dismissed the petitioner's arguments. There was no premature issuance of whole departure orders since the Sandigan Bayan had already acquired jurisdiction over the case when the informations were filed before the Sandigan Bayan. It also pointed out that MUPAS was inapplicable since, in the mentioned case, the criminal complaint was still on the investigation stage and still subject to the review of the provincial prosecutor prior to the filing of information in court. In denying the motion filed by the petitioner, the Sandigan Bayan ruled that there is nothing premature in and no legal impediment whatsoever to the issuance of HDOs in these cases by the court following a valid judicial determination of probable cause to hold movement for trial. It would be illogical to order her arrest but freely allow her to depart for abroad. The Sandigan Bayan also stated that petitioner's contention that there is no case against her filed and pending before the court is untenable. Such action of the court in suspending the proceedings did not oust it of jurisdiction over the cases and over the person of the accused. Petitioner Garcia remains charged before the court with the offenses described in the informations filed. Petitioner then filed the instant petition for certiorari, praying, among others, that the HDOs be lifted and set aside. The petitioner argues that the Sandigan Bayan does not have the authority of any law or governmental regulation to issue an HDO. The petitioner further contends that the issuance of HDOs against her was violative of her fundamental right to travel, which may only be impaired in the interest of national security, public safety, or public health as may be provided by law. Since the Sandigan Bayan was not given the express authority by a law to issue an HDO, its act of restraining her liberty of movement through the issuance of HDO is a grave and continuing threat to her constitutional right to travel. The issue in this case is whether or not the lack of a law that specifically grants the Sandigan Bayan the authority to issue HDOs and its continued practice to do so amounts to an unreasonable curtailment of the right to travel. The court ruled in the negative. The right to travel, while a fundamental right, is not absolute. Section 6, Article 3 of the 1987 Constitution states that neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. Based on the foregoing, the right to travel may be impaired, if necessary, in interest of national security, public safety, or public health. Apart from the presence of these exclusive grounds, there is a further requirement that there must be a law authorizing the impairment. The requirement of a law ensures that the necessity for the impairment has undergone the validation and deliberation of Congress before its enactment. The strict requirement for the concurrence of these two elements are formidable enough to serve as safeguard in the full enjoyment of the right to travel. In Silverio versus CA, the court explained that Article 3, Section 6 of the 1987 Constitution should be interpreted to mean that while the liberty of travel may be impaired even without court order, the appropriate executive officers or administrative authorities are not armed with arbitrary discretion to impose limitations. They can impose limits only on the basis of national security, public safety, or public health, and as may be provided by law, a limited phrase which did not appear in the 1973 text. The petitioner may be correct in arguing that there is no law particularly vesting the Sandigan Bayan the authority to issue HDOs, but this is precisely because the same is not necessary for it to exercise this power. The court reiterated that, aside from constitutional limitations, there are also statutory and inherent limitations on the right to travel. In Leave Division OAS-OCA versus Houston's, the court enumerated some of the statutory limitations on the right to travel. An example of which is Republic Act Number 9262. This law restricts movement of an individual against whom the protection order is intended. On the other hand, the power to issue HDO is an exercise of the court's inherent power to preserve and to maintain the effectiveness of its jurisdiction over the case and the person of the accused. They do not require legislative conferment or constitutional recognition. They coexist with the grant of judicial power. Verily, inherent powers are brought into existence by the grant of judicial power to the courts to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Thus, the courts may regularly apply their inherent powers to take some action that has not been specifically authorized by the Constitution, written rule, or statute. Necessarily included in the grant of jurisdiction is the power to ensure that its exercise shall be effective. When by law jurisdiction is conferred on a court or judicial officer, all auxiliary writs, processes, and other means necessary to carry it into effect may be employed by such court or officer. Inherent powers, in effect, facilitate and reinforce the court's exercise of its specific powers. The power to issue whole departure order is properly subsumed under the inherent power of the courts because it is an implement by which the jurisdiction of the court is preserved. Contrary to the allegation of the petitioner, the issuance of HDOs is not mere practice that has ripened into a law or rule. The Sandigan Bayan issues HDO because it has the authority to do so, and this attaches from the moment it acquired jurisdiction over the case and over the person. In this case, jurisdiction over the case was acquired when the informations against the petitioner were filed with the Sandigan Bayan, and thereafter, the petitioner voluntarily submitted herself to the jurisdiction of the court by posting bail of 30,000 pesos for each of the cases filed against her. Upon posting bail, the accused subjects himself to the jurisdiction of the court and may validly be restricted in his movement and prohibited from leaving this jurisdiction. Thus, it is not entirely correct for the petitioner to argue that the issuance of HDOs amounted to an unreasonable restriction on her liberty of movement or right to travel. The truth of the matter is that she was already under restricted right to travel when she submitted to the jurisdiction of the Sandigan Bayan by posting bail. The issuance of the HDO is a process complementary to the granting of bail since it puts the Bureau of Immigration on notice that a certain person is charged before the courts of law and must not be allowed to leave our jurisdiction without the permission of the court. Hence, the absence of a law that specifically grants the Sandigan Bayan the authority to issue HDOs does not amount to an unreasonable curtailment of the right to travel, because such law is not necessary for the Sandigan Bayan to exercise this power. It's also worthy to note the court's declaration that, notwithstanding the issuance of HDOs, the petitioner is not absolutely prohibited from traveling abroad. She was only restricted from leaving the country, as this would place her beyond the jurisdiction of our courts and may render nugatory the process and proceedings being conducted in the cases against her. Nonetheless, she may at any time request for permission to travel abroad, citing grounds for its necessity. In numerous instances, the Sandigan Bayan granted permissions to travel abroad based on meritorious grounds and on humanitarian considerations, provided that certain conditions are complied with. In this case, however, there is no showing that the petitioner has asked permission to travel from the Sandigan Bayan and was denied of it. The last case I will be discussing is Oposa versus Factoran et al. Under the topic of non-impairment of contracts. The controversy arose from the complaint filed before the RTC questioning the continued grant of timber license agreements or TLAs for commercial logging purposes, as it focuses on a fundamental legal right, the right to a balanced and healthful ecology. The complaint was instituted as a taxpayers' class suit and alleges that the plaintiffs are all citizens of the Republic of the Philippines, taxpayers, and entitled to the full benefit, use, and enjoyment of the natural resource treasure that is the country's virgin tropical rainforest. The petitioners allege that public records reveal that the defendants' predecessors have granted TLAs to various corporations to cut the aggregate area of 3.89 million hectares for commercial logging purposes. They also allege that plaintiffs have a clear and constitutional right to a balanced and healthful ecology and are entitled to protection by the state in its capacity as the parents aggregate. Despite receipt of the final demand to cancel all logging permits in the country, defendant fails and refuses to cancel the existing TLAs to the continuing serious damage and extreme prejudice of plaintiffs. The original defendant, Secretary Factoran Jr., filed a motion to dismiss the complaint based on two grounds. First, the plaintiffs have no cause of action against him, and second, the issue raised by the plaintiffs is a political question which properly pertains to the legislative or executive branches of government. In granting the motion to dismiss, the respondent judge stated, among others, that the granting of the reliefs prayed for would result in the impairment of contracts, which is prohibited by the fundamental law of the land. This led the plaintiffs to file this special civil action for certiorari under Rule 65 on the ground that the respondent judge gravely abused his discretion in dismissing the action. As to the invocation by the respondent judge of the Constitution's non-impairment clause, petitioners maintain that the same does not apply in this case because TLAs are not contracts. They likewise submit that even if TLAs may be considered protected by the said clause, it is well settled that they may still be revoked by the state when public interest so requires. So the issue in this case is whether or not the non-impairment clause is applicable because timber licenses are contracts. The court ruled in the negative. In ruling that the non-impairment clause is not applicable, the court has raised three main points. First, the respondent secretary did not even invoke in his motion to dismiss the non-impairment clause. If he had done so, he would have acted with utmost infidelity to the government by providing undue and unwarranted benefits and advantages to the timber license holders because he would have forever bound the government to strictly respect the said licenses according to their terms and conditions, regardless of changes in policy and the demands of public interest and welfare. He was aware that, as correctly pointed out by the petitioners, into every timber license must be read Section 20 of PD number 705, which provides that when the national interest so requires, the President may amend, modify, replace, or rescind any contract, concession, permit, licenses, or any other form of privilege granted herein. In Tan versus Director of Forestry, this court held that a timber license is not a contract within the purview of the Due Process Clause. It is only a license or privilege which can be validly withdrawn whenever dictated by public interest or public welfare, as in this case. The granting of license does not create irrevocable rights, neither is it property or property rights. Since timber licenses are not contracts, the non-impairment clause, which reads, "No law impairing the obligation of contract shall be passed," cannot be invoked. Second, even if it is to be assumed that the same are contracts, the instant case does not involve a law or even an executive issuance declaring the cancellation or modification of existing timber licenses. Hence, the non-impairment clause cannot as yet be invoked. Nevertheless, granting further that a law has actually been passed mandating cancellations or modifications, the same cannot still be stigmatized as a violation of the non-impairment clause. This is because, by its very nature and purpose, such a law could have only been passed in the exercise of the police power of the state for the purpose of advancing the right of the people to a balanced and healthful ecology, promoting their health and enhancing the general welfare. The court has once stated that the constitutional guarantee of non-impairment of obligations of contract is limited by the exercise of the police power of the state in the interest of public health, safety, moral, and general welfare. The reason for this is that under our form of government, the use of property and the making of contracts are normally matters of private and not of public concern. The general rule is that both shall be free of governmental interference. But neither property rights nor contract rights are absolute. For government cannot exist if the citizen may at will use his property to the detriment of his fellows or exercise his freedom of contract to work them harm. Equally fundamental with the private right is that of the public to regulate it in the common interest. In court, the non-impairment clause must yield to the police power of the state. Finally, it is difficult to imagine, as the trial court did, how the non-impairment clause could apply with respect to the prayer to enjoin the respondent secretary from receiving, accepting, processing, renewing, or approving new timber licenses for, save in cases of renewal, no contract would have as of yet existed in the other instances. Moreover, with respect to renewal, the holder is not entitled to it as a matter of right. Hence, the non-impairment clause is not applicable in this case. In sum, the following are the case doctrines earlier discussed. First, in the letter of Tony Valenciano holding religious rituals at the Hall of Justice building in Quezon City, the court ruled that the holding of religious rituals in the halls of justice, as a mere case of accommodation, does not violate the constitutional provision on the separation of church and state and the constitutional prohibition against the appropriation of public money or property for the benefit of a sect, church, denomination, or any other system of religion. The basement of the QC Hall of Justice has remained to be a public property devoted for public use because the holding of Catholic masses therein is a mere incidental consequence of its primary purpose. In Soriano versus People, the court ruled that plain and simple insults directed at another person cannot be elevated to the status of religious speech. In Genuino versus De Lima et al. And Macapagal Arroyo versus De Lima et al., the court ruled that DOJ Circular Number 41 is unconstitutional because of the absence of a law authorizing the Secretary of Justice to issue whole departure orders, watch list orders, or allow departure orders. Unlike the courts, the DOJ does not have an inherent power to issue HDOs or to restrict the right to travel in any way. DOJ is limited to the powers expressly granted to it by law and may not extend the same on its own accord or by any skewed interpretation of its authority. In the case of Garcia versus Sandigan Bayan et al., the court ruled that the power to issue HDOs is an exercise of the court's inherent power to preserve and to maintain the effectiveness of its jurisdiction over the case and the person of the accused. Hence, the absence of a law that specifically grants the Sandigan Bayan the authority to issue HDOs does not amount to an unreasonable curtailment of the right to travel because such law is not necessary for the Sandigan Bayan to exercise this power. Lastly, in the case of Oposa versus Factoran, the court ruled that a timber license is not a contract within the purview of the Due Process Clause. It is only a license or privilege which can be validly withdrawn whenever dictated by public interest or public welfare, as in this case. Since timber licenses are not contracts, the non-impairment clause cannot be invoked. I will now give the floor to Ms. Vista.
Good day, everyone. This is Maria Jazamal Vista, and today we're going to talk about 5 cases. Number 1 will be the Land Bank of the Philippines versus Republic, which talks about the non-impairment of contracts. The second is the Yap versus People, which talks about rights under investigation, as well as People versus Moreno and Porteria versus People. And lastly, Extra Excel International Philippines Incorporated versus Honorable Cahugal, which will talk about the right to bail. First, what is Article 3, Section 10 of the 1987 Constitution? It provides that no law impairing the obligation of contracts shall be passed. So let us talk about the case of Land Bank of the Philippines versus Republic. The facts of the case are as follows. A mother title registered under OCT number P2823 was issued on September 26, 1969 in favor of one Angelito Bugayong, which emanated from sales patent number 4576 issued in Bugayong's name on September 22 the same year, covering a parcel of land located in Bocana, Cabacan, Davao City with an area of 41,276 square meters. It was originally identified and surveyed as lot number 4159. It was marshy and underwater during high tide. It used to be a portion of a dry riverbed near the mouth of Davao River. The land was initially subdivided into 4 lots under the subdivision plan approved by the Commissioner of Land Registration on April 23, 1971. Consequently, the said mother title was cancelled and new transfer certificates of title was replaced, all in the name of Bugayong. Bugayong sold all of the 4 lots to different persons. Lot number 4159A, which was then under TCT number T32769, was sold to spouses Lourdes and Candido Du. Accordingly, said TCT was cancelled and replaced in the name of the spouses Du. Afterwards, the spouses Du further caused the subdivision of the land into 2 lots. They sold one of said lots to spouses Felix and Guadalupe Dayola, and the other remaining lot was retained by the spouses Du. Subsequently, the Du spouses was cancelled and it was replaced by another TCT registered in the name of Lourdes Farms Incorporated, subject of this case. Lourdes Farms Incorporated mortgaged this property to petitioner Land Bank of the Philippines on April 14, 1980. On July 15, 1981, some residents of the land covered by the matter title, particularly those along Bolton Diversion Road, filed a formal petition before the Bureau of Lands. So investigation ensued to check the legitimacy of the mother title, and they found out that at the time sales patent number 4576 was issued to Bugayong, the land it was covered was still within the forest zone, classified under Project Number 1, LC 47, dated August 6, 1923. It was released as alienable and disposable land only on March 25, 1981. The land was marshy and covered by sea water during high tide, and Bugayong was never in actual possession of the land. In view of the foregoing findings, the Bureau of Lands resolved that the sales patent in favor of Bugayong was improperly and illegally issued, and that the Director of Lands had no jurisdiction to dispose of the subject land. A complaint was then instituted before the RTC in Davao Branch 15 for the cancellation of title or patent and reversion of the land covered by OCT number P2823 into the mass of public domain. The complaint as amended was filed against Bugayong and other present owners and mortgagees of the land, such as Lourdes Farms Incorporated, and the latter's mortgagee, petitioner, Land Bank of the Philippines. Land Bank of the Philippines claimed in its answer that it is a mortgagee in good faith and for value. It prayed that should TCT number T57348 of Lourdes Farms Incorporated be annulled by the court, Lourdes Farms Incorporated should be ordered to pay its outstanding obligation to Land Bank of the Philippines or to provide a new collateral security. Now, the ruling of the lower courts are as follows. The Regional Trial Court, in its judgment rendered on July 9, 1996, explained that titles issued to private parties by the Bureau of Lands are void ab initio if the land covered by it is a forest land. It went further by stating that if the mother title is void, all titles arising from the mother title are also void. It thus ruled in favor of the Republic. Now, the Court of Appeals dismissed the appeal of the Land Bank of the Philippines as well as its motion for reconsideration by citing Republic versus Reyes, that mortgagees of non-disposable lands, where titles thereto were erroneously issued, acquire no protection under the land registration law. Appellants, mortgagees, proper recourse, therefore, is to pursue their claims against their respective mortgagors and debtors. Now, the issue is whether the Court of Appeals erred in not finding petitioner Land Bank of the Philippines mortgage right and interest over the subject land as valid and subsisting under the constitutional guarantee of non-impairment of contracts. The ruling of the Supreme Court is as follows. No, the Court of Appeals did not err in not finding that the interest of Land Bank of the Philippines is valid and subsisting under the constitutional guarantee of non-impairment of contracts. There is no impairment of contract in this case, but a valid exercise of police power of the state. The constitutional guarantee of non-impairment of contracts may not be used by Land Bank of the Philippines to validate its interest over the land as mortgagee. The state's restraint upon the right to have an interest or ownership over forest lands does not violate the constitutional guarantee of non-impairment of contracts. Said restraint is a valid exercise of the police power of the state, as emphasized by the court in Director of Forestry versus Munoz. Because of the importance of forests to the nation, the state's police power has been wielded to regulate the use and occupancy of forest and forest reserves. Preservation of our forest lands could entail intrusion upon contractual rights, as in this case, but it is justified by the Latin maxims Salus populi est suprema lex and Sicotere tuud alienum non ledas, which call for the subordination of individual interest to the benefit of the greater number. Now, let's talk about Article 3, Section 12. First paragraph provides that any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. Second paragraph, No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. Lastly, the law shall provide for penal and civil sanctions for violations of this section, as well as compensation to and rehabilitation of victims of torture or similar practices and their families. The next case is Johnny Yap versus People, and it talks about the rights under investigation, as I have mentioned earlier, under Section 12 of the Bill of Rights. In an information filed by the Assistant City Prosecutor of Manila, herein petitioner Johnny Garcia Yap was charged with the crime of attempted murder. It was alleged that on or about November 5, 2012, in Manila, the said accused did then and there willfully, unlawfully, and feloniously with intent to kill, with treachery and evident premeditation, commence the commission of the crime of murder directly by overt acts by forcing one, George Hao Ang, to drink coffee which was laced with benzodiazepines, a sleep-inducing psychoactive drug, without the knowledge of the said George Hao Ang, which immediately made the latter fall asleep. And while he was sleeping, the said accused repeatedly hit the said George Hao Ang on the head with a rolling pin that caused profuse bleeding thereof. But said accused did not perform all the acts of execution which would have produced the crime of murder. As a consequence, by reason of some cause other than his own spontaneous desistance. That is said, George Hao Ang was able to walk away from the accused and run fast for his safety. Upon arraignment, Yap entered a plea of not guilty. However, during pretrial, he manifested that he invokes self-defense. As a consequence, trial on the merits ensued, whereby the defense presented its evidence in chief first. The ruling of the lower courts is that the RTC rendered judgment finding Yap guilty as charged. The Court of Appeals affirmed the ruling of the RTC and held that by invoking self-defense during pretrial, Yap has admitted performing the criminal act, and it is incumbent upon him to prove the presence of any claimed justifying circumstance to which he failed to do so. Now, what is the main issue here? The main issue is that whether the petitioner should not be bound by his previous counsel's gross mistake in invoking self-defense, as the latter did not explain the nature and concept of such defense to him. The ruling of the Supreme Court provides that no, it is actually a well-settled rule that the client is bound by the counsel's conduct, negligence, and mistakes in handling the case, and the client cannot be heard to complain that the result might have been different had his lawyer proceeded differently. An exception to this rule is consistently enunciated in a number of cases, and that is when the negligence of counsel had been so egregious that it prejudiced his client's interest and denied him his day in court. In the instant case, the general rule applies and the above exception finds no application because petitioner failed to prove that his previous counsel's act of invoking self-defense on petitioner's behalf is tantamount to gross negligence, as to deprive petitioner of his right to due process. The court agrees with the Office of the Solicitor General that records would show that petitioner was ably represented by his former counsel during trial and was not denied due process as shown by the following. First, petitioner and his wife were able to take the witness stand where they themselves were personally able to present their case to the court during direct examination. Second, during cross-examination, petitioner was able to knowingly and intelligently answer the questions propounded to him by the prosecutor and the trial judge. And third, when the prosecution presented its case, petitioner, through his former counsel, was able to examine the witnesses and the evidence presented. So, to sum it up, the right to be assisted by counsel is an indispensable component of due process and criminal prosecution, and that such right is one of the most sacrosanct rights available to the accused. However, in this case, the right to counsel proceeds from the fundamental principle of due process, which basically means that a person must be heard before being condemned. The due process requirement is a part of a person's basic rights. It is not a mere formality that may be dispensed with or performed perfunctorily. The right to counsel must be more than just the presence of a lawyer in the courtroom or the mere propounding of standard questions and objections. The right to counsel means that the accused is amply accorded legal assistance extended by a counsel who commits himself to the cause for the defense and acts accordingly. The right assumes an active involvement by the lawyer in the proceedings, particularly at the trial of the case. His bearing constantly in mind of the basic rights of the accused, his being well versed on the case, and his knowing the fundamental procedures, essential laws, and existing jurisprudence. The right of an accused to counsel finds substance in the performance by the lawyer of his sworn fidelity to his client. Tersely put, it means an efficient and truly decisive legal assistance and not a simple perfunctory representation. Next is People versus Gerald Moreno. In this case, on November 16, 2001, at around 2:15 in the morning, Alderisa Mijares was awakened from her sleep when a hard object hit her head. When she turned on the lights, a man wearing khaki shorts and a white t-shirt leaped on their bed and repeatedly stabbed her husband, Cecil Mijares, on the leg and chest. Mijares was able to kick the man out of the room and even close the door. Immediately thereafter, Mijares collapsed and fell on the floor. Adalriza shouted for help, and their neighbor, Virgie Perry, came to their rescue. Virgie sought assistance from their neighbors, Noli Corrales and Michael Benaflor, in bringing Mijares to the Philippine General Hospital. Unfortunately, Mijares died while undergoing treatment. Adalriza still did not know the name of her husband's killer, but she vividly remembered his face after having witnessed the stabbing. A police cartographer prepared a sketch of the suspect based on Adalriza's description. In the afternoon of the same day, the police received a call from Virgie informing them that the appellant, who fitted the description of the suspect, was in the vicinity of his house. According to Virgie, she heard rumors that the appellant was responsible for the killing of Mijares. Acting on Virgie's tip, SPO1 Olivario invited Appellant Moreno to the police station for an interview regarding the killing that transpired, to which Appellant acceded. The police officers then summoned Adalriza to take the police station, where she positively identified Appellant as the person who stabbed her husband. SPO1 Olivario thus arrested Appellant and informed him of his constitutional right to remain silent and to have a competent counsel of his choice. Appellant, however, did not respond. Hence, SPO1 Olivario merely asked for his name and then prepared the crime report, booking and arrest sheet, and referral to inquest. The defense vehemently denied the version of the prosecution and interposed that at the time of the incident, the appellant was sleeping at his house in Santa Ana, Manila, where his mother, father, siblings, and son likewise lived. He was awakened by a loud noise, and when he inquired about it from his father, he was told that there was a robbery in the vicinity. He then went out of their gate, where their neighbor, Junior Santos, told him to get a taxi cab. When it arrived, he assisted his neighbors to carry Mijares into the taxi cab to be brought to the hospital. Thereafter, he went back to sleep and was only awakened at 11 in the morning when armed police officers were already inside his room. The police officers invited him to the police station for an investigation, and he voluntarily went with them. Appellant insisted that he never knew Mijares, and he saw the victim for the first time when he assisted in carrying him to the taxi cab. During the time of the incident, he was wearing a gray t-shirt and black pants, contrary to Adalriza's description of the clothes of her husband's killer. However, he could not impute any reason as to why Adalriza would ever testify against him. Appellant pleaded not guilty. The ruling of the lower courts are as follows. The RTC rendered a decision finding appellant guilty of murder with treachery having attended the attack. The appellate court, finding no reversible error, upheld the trial court's decision. The Court of Appeals held that the lone positive and credible testimony of the eyewitness was sufficient to support the appellant's conviction. Any inconsistencies in the testimony of Adalriza did not destroy the strength of her testimony. The appellate court stressed that there is no rule requiring for a police lineup in the identification of offenders, and that the same is not indispensable for the proper and fair identification of offenders. The CA also held that the defense of alibi cannot prevail over and is worthless in the face of the positive identification by a credible witness. Moreover, appellant's alibi was inherently weak as he failed to prove that it was physically impossible for him to have been present at the scene of the crime. The appellate court disregarded the argument that he was illegally arrested because the objection was not raised before arraignment and was deemed waived. So the issue is whether the identification, arrest, and conduct of custodial investigation against the appellant was illegal and irregular for depriving him of his constitutional right to have a counsel present. The Supreme Court said no, the contention is void of merit. A police lineup is not indispensable for the proper and fair identification of offenders. The important consideration is for the victim to positively declare that the persons charged were the malefactors. In People versus DeHanke Jr., this court explained the procedure for out-of-court identification and the test to determine the admissibility of such identifications in the manner. Out-of-court identification is conducted by the police in various ways. It is done through show-ups where the suspect alone is brought face-to-face with a witness for identification. It is done through mugshots where photographs are shown to the witness to identify the suspect. It is also done through lineups where a witness identifies the suspect from a group of persons lined up for the purpose. In resolving the admissibility of and relying on out-of-court identification of suspects, courts have adopted the totality of circumstances test, where they consider the following factors. Number one, the witness' opportunity to view the criminal at the time of the crime, the witness's degree of attention at the time, the accuracy of any prior description given by the witness, the level of certainty demonstrated by the witness at the identification, the length of time between the crime and the identification, and the suggestiveness of the identification procedure. Applying the totality of circumstances test, the court finds appellant's out-of-court identification to be reliable and thus admissible. To recall, Adalriza, after being awakened when a hard object hit her head and after she switched on the lights inside the room, had a clear and direct view of the attack on her husband and the perpetrator. Moreover, she described with certainty the assailant to the police cartographer barely hours from the time of the incident, which description matched the facial features of the appellant, whom she subsequently identified as the assailant. In other words, the interval between the time she witnessed the crime and her identification of the appellant was merely a matter of hours, leaving no room for her recollection to be tainted. Verily, it was Adalriza's own description that led to the apprehension of the appellant. There was no evidence on record indicating any hint of a suggestion from the police officer who presented the appellant to Adalriza. Hence, the identification of the appellant as the culprit of the crime stands. About the legality of the arrest, it bears stressing that questions on arrest shall be made before arraignment, and failure to object to the illegality of arrest constitutes a waiver on the part of the accused. It is settled that Any objection to the manner of arrest must be opportunely raised before he enters his plea. Otherwise, the objection is deemed waived. Here, the records show clearly that the objection was only raised on appeal. The court ruled in People versus Calais and Samson that appellant is now stopped from questioning any defect in the manner of his arrest as he failed to move for the quashing of the information before the trial court. Consequently, any irregularity attendant to his arrest was cured when he voluntarily submitted himself to the jurisdiction of the trial court by entering a plea of not guilty and by participating in the trial. Even assuming that the appellant's arrest was irregular, still it is not a jurisdictional defect and objection thereto is waived where the person arrested submits to arraignment without objection. There was no violation of appellant's right to counsel during custodial investigation. The records show that appellant was informed of his constitutional right when he was arrested. Since he chose to remain silent, he was not interrogated and no statement or evidence was extracted against him. Neither was any evidence presented in court that was supposedly obtained from him during custodial investigation. The fourth case is Porteria versus People. The facts are as follows. Wilfredo Christian Mien is a registered owner of a blue Honda motorcycle. It was a 2004 model with the engine number and the chassis number, as you can see in the screen. According to the prosecution, Christian used his motorcycle on December 10, 2010 at about 6 a.m. when he went to work at St. John Hospital in Banganiwan Drive, Naga City. He parked his motorcycle in front of the hospital in the parking area of the Nazareno drugstore. After finishing his shift at about 2 p.m., Christian discovered that his motorcycle was no longer in its parking spot. Unable to find his motorcycle, Christian went to the PNP Naga City police office to report that his motorcycle was stolen. The following day, he went to the PNB Provincial Highway Patrol Group to report the incident again. On February 1, 2011, the police officers of Ocampo, Camarines Sur supposedly received a report that there was a suspicious person with something tacked in his waist. The chief of police of the Ocampo Police Station, Police Inspector Samuel Diazes Villamur, dispatched a team to verify the report. The report eventually resulted in the arrest of Marvin along the highway of Barangay San Francisco, Ocampo, Camarines Sur for the illegal possession of firearm. He was then thereafter subjected to a search of his body and of the bag allegedly found in his possession. Inside the bag, the arresting officer found an assortment of documents, including photocopies of the OR and CR of Christian's stolen motorcycle. At the Ocampo police station, Marvin was asked regarding the documents discovered in his bag. Stated that Marvin responded voluntarily, informing the police that the motorcycle was in the possession of a certain Felix Maratas in Santa Rosa, Laguna. Later on, Police Inspector Villamur sent a text message to Christian's brother, notifying him that Marvin was arrested and that they found the registration of the stolen motorcycle in his possession. Christian and his brother then went to the Ocampo police station where they were advised that Marvin has been transferred to the Naga City District Jail. On February 5, 2011, the mother of Christian, Virgie Mien, went to the Naga City District Jail intending to talk to Marvin. She asked Marvin about the registration of the subject motorcycle found in his possession, to which Marvin apparently replied by confessing his guilt. Virgie testified that Marvin admitted taking Christian's motorcycle and going on a road trip to Quezon. Marvin also allegedly told Virgie that he left the motorcycle with a certain Insan Joy, whose address is Phase 5 Southfield Subdivision, Santa Rosa, Laguna. That night, Virgie called her friend, who was a police officer, to relay the information she obtained from Marvin. This friend of hers, Police Superintendent Teodorico Bolitic, called her a week later to inform her that the motorcycle was not at the address Marvin provided. The motorcycle was later found in a checkpoint placed at the road of Barangay Caingin, Santa Rosa, Laguna on March 11, 2011, driven by one Albert Orino. Marvin, for his part, denied the accusations of the prosecution. According to him, he met a friend at Barangay San Francisco, Campo Camarines Sur on February 1, 2011. His friend, a certain Francis Aguilar, was driving a motorcycle and carrying a bag. His friend left the area, leaving behind the motorcycle with the bag on top of it. Several moments later, police officers approached Marvin and invited him to go to the police station. The invitation was purportedly pursuant to a report of a suspicious person in the area. Marvin refused, but the police officers forced him to go with them. The police officers brought him to the Ocampo police station, where he was interrogated and detained. At no point was Marvin informed of his rights. When the police officers told him about the gun recovered inside his bag, Marvin denied owning the bag, much less its contents. On October 27, 2011, the information against Marvin, Albert, and Felix was filed with the RTC of Naga City, charging them with the violation of RA number 6539. The ruling of the lower court is that the trial court found Marvin Porteria guilty beyond reasonable doubt for the violation of RA number 6539, otherwise known as the Anti-Carnapping Act of 1972. The CA affirmed the RTC's decision. Marvin now alleges that the trial court and the CA should not have considered the supposed discovery of the stolen motorcycles ORNCR in his possession because the search was not legal. He further argues that the extrajudicial confession he made to Virgie was not freely and voluntarily made. Based on these grounds, Marvin asserts that his conviction does not hold water. So the main issue is that whether Marvin's alleged admissions of guilt suffice to convict him for carnapping. The Supreme Court said that no, Marvin's alleged admissions of guilt do not suffice to convict him for carnapping. Section 12, Article 3 of the 1987 Constitution states that persons under investigation for the commission of an offense should be informed of their right to remain silent and their right to counsel. These rights may not be waived except in writing and in the presence of a counsel. Any confession or admission obtained in violation of this provision is inadmissible as evidence against the accused. This principle is further reiterated in Section 2 of RA number 7438. Under this statute, extrajudicial confessions made by a person arrested, detained, or under custodial investigation must fulfill the following requirements. Particularly, any extrajudicial confession made by a person arrested, detained, or under custodial investigation shall be in writing and signed by such person in the presence of his counsel or in the latter's absence upon a valid waiver and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. These safeguards are intended to prevent the practice of extracting coerced confessions, no matter how slight, which could lead the accused to make false admissions. They are meant to insulate the accused from coercive psychological, if not physical, atmosphere of a custodial investigation. The trial court, in convicting Marvin for the crime of carnapping, relied on several circumstantial pieces of evidence. There include his supposed voluntary admission to Police Inspector Villamer that the motorcycle is in the possession of a certain Felix. This admission, as shown in the following testimony of Police Inspector Villamer, was given after Marvin was arrested and taken to the police station for further investigation. At that time, Marvin was already under custodial investigation. Having been placed in the custody of the police or deprived of his freedom of action in a significant manner. Thus, when the police officers asked Marvin regarding the discovery of the motorcycle's registration documents in his possession, Marvin's right to counsel automatically attached. Furthermore, his answer constitutes an implied admission of guilt, which should have been done in writing with the assistance of his counsel or after a valid waiver of these rights. Remarkably, neither Police Inspector Villamur nor SPO for Picaris testified that Marvin was informed of his rights, much less granted the opportunity to obtain a counsel of his own choice. Marvin, on the other hand, narrated in his direct examination that he was not informed of his rights. It bears reiterating that when the police officers of Ocampo Camarines Sur began questioning Marvin about the items found in his possession, there should have been a counsel present to assist Marvin. Without the assistance of a counsel and in the absence of a valid waiver of this right, Marvin's voluntary answer to Police Inspector Villamur is inadmissible as evidence of his guilt. This notwithstanding, the court should still inquire upon the voluntariness of the confession. The prosecution must establish that the accused spoke freely without inducement of any kind and fully aware of the consequences of the confession. This may be inferred from the language of the confession as when the accused provided details known only to him or her. In the present case, the court cannot determine the voluntariness of Marvin's supposed confession to Virgie because it was not reduced into writing or recorded in another manner. The court can only rely on the testimony of Virgie as to the substance of Marvin's confession. Aside from her testimony, there is no independent evidence that establishes the voluntariness and substance of Marvin's alleged extrajudicial confession. The testimony of Virgie as to the supposed confession of Marvin may nonetheless be admitted as an independently relevant statement, which proves only the fact that such statement was made. The admission of this testimony does not necessarily mean that the court is persuaded. Virgie is competent to testify only as to the substance of what she heard, not the truth thereof. Her testimony by itself is not sufficient proof of its veracity. As the court explained in People v. Satorre, at any rate, an extrajudicial confession forms but a prima facie case against the party by whom it is made. Such confessions are not conclusive proof of that which they state. It may be proved that they were uttered in ignorance or levity or mistake, and hence they are at best to be regarded as only cumulative proof, which affords but a precarious support and on which, when uncorroborated, a verdict cannot be permitted to rest. So the court emphasizes that an extrajudicial confession is not a sufficient ground for conviction unless it is corroborated by either direct or circumstantial evidence. If it is the latter, the accused may be convicted when there is more than one circumstance, the facts from which the inferences are derived and proven, and the combination of jail, the circumstances is such as to produce a conviction beyond reasonable doubt. Thus, the petition in this case was granted and the accused was acquitted. Lastly, for the last concept, Article 3, Section 13 provides that all persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall, before conviction, be bailable by sufficient sureties or be released or recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. So the last case is about Extra Excel International Philippines Incorporated versus Honorable Cajugal. This is an administrative complaint for gross ignorance of the law, gross inefficiency, grave abuse of authority, and evident partiality filed by complainant Extra Excel International Philippines Incorporated through its representative attorney Romel Oliva against respondent Judge Afable Cajugal relative to criminal case People of the Philippines versus I. Katipunan. Complainant narrated that an information for qualified theft was filed against Katipunan, complainant's former inventory control service assistant. The case was referred to Branch 96 of the RTC of Quezon City with respondent as presiding judge. Complainant alleged that after the filing of the information, respondent judge did not set the case for arraignment nor issue a warrant of arrest. Instead, he granted the accused motion for preliminary investigation and motion to defer further proceedings. Incidentally, in its May 30, 2014 decision, the Court of Appeals found grave abuse of discretion on the part of respondent judge in granting the accused motion for preliminary investigation. Meanwhile, there being no resolution on the preliminary investigation despite the lapse of the 60-day period and pursuant to AM number 11610 of the Supreme Court, which mandates accused arraignment upon the lapse of the 60-day period, complainant filed a motion to set case for arraignment. Upon comment of the accused, respondent judge ordered the City Prosecution Office of Quezon City to conclude the ongoing investigation. Thereafter, the City Prosecution Office resolved to affirm the earlier finding of probable cause. On March 24, 2014, complainant filed a motion for issuance of whole departure order, which motion remains unresolved. Meanwhile, the accused filed on March 28, 2014, an omnibus motion for judicial determination of probable cause, recall of warrant of arrest, and deferment of proceedings, thereby prompting complainant to file a comment or opposition and motion for inhibition. Respondent judge eventually arraigned accused on June 9, 2014. However, instead of ordering the accused commitment and despite the offense being non-bailable, respondent judge allowed the accused to go home. On June 13, 2014, the accused filed a petition for bail. During the bail hearing on June 24, 2014, respondent judge found the filing thereof premature and issued a warrant of arrest against the accused. However, instead of committing the accused at the Quezon City Jail, he was instead detained at the Criminal Investigation and Detention Unit of Central Police District, Camp Caringal, Quezon City. Thereafter, respondent judge scheduled the bail hearing on June 30, 2014, despite manifestation by complainant's counsel of his unavailability on said date. During the June 30, 2014 bail hearing, respondent judge declared the petition for bail submitted for resolution due to the absence of complainant's counsel. On even date, respondent judge issued an order granting the bail petition and denying the motion for inhibition. Finally, complainant claimed that respondent judge attempted to fast-track the proceedings in the criminal case by rescheduling the redirect examination of the prosecution's witness from February 17, 2015, as earlier agreed by the parties, to December 17, 18, and 22, 2014, in view of his impending retirement on December 29, 2014. According to the complainant, the foregoing events clearly showed respondent judge gross inefficiency, incompetence, gross ignorance of the law, grave abuse of authority, and evident partiality. Complainant argued that respondent judge was guilty of, among others, gross ignorance of the law and evident partiality in granting the petition for bail, despite complainant's pending motion for reconsideration and her motion to set the hearing to another date. The report and recommendation of the Office of the Court Administrator provides that on the charge of gross ignorance of the law and evident partiality for granting the petition for bail without conducting a hearing to prove whether the evidence of guilt is strong or not, which will form the basis for granting or denying the petition for bail, we agree with the complainant. In this case, when respondent judge set the hearing for bail on June 30, 2014, the private prosecutor manifested his unavailability on the said date. But this notwithstanding, respondent judge pushed through with the hearing. Immediately, complainant through the lawyer filed an urgent motion for reconsideration explaining his absence during the June 30, 2014 hearing. Nonetheless, respondent judge granted the petition for bail for failure of the private prosecutor and the witnesses to appear and in the absence of any objection from the public prosecutor. The law and settled jurisprudence demand that the hearing be conducted before bail could be fixed for the temporary release of the accused, if bail is at all justified. The absence of any objection from the prosecution in such cases is not a basis for the grant of bail, for the judge has no right to presume that the prosecutor knows what he is doing on account of the familiarity with the case. Said reasoning is tantamount to ceding to the prosecutor the duty of exercising judicial discretion to determine whether the guilt of the accused is strong. Judicial discretion is the domain of the judge before whom the petition for provisional liberty will be decided. The mandated duty to exercise discretion has never been reposed upon the prosecutor. There is gross ignorance because the need for hearing before bail is fixed or granted is so basic that the respondent judge ought to know that. So in this instance, good or bad faith is of no moment, unlike in the other instance of gross ignorance exhibited by respondent judge when he granted the motion for preliminary investigation. Respondent judge is also liable for gross ignorance of the law for granting the petition for bail without the benefit of a hearing. Gross ignorance of the law or procedure is classified as serious charge and should be penalized by dismissal from the service, forfeiture of all or part of the benefits as the court may determine, and disqualification from reinstatement or appointment to any public office, including government-owned or controlled corporations, provided, however, that the forfeiture of benefits shall in no case include accrued leave credits. There is also suspension from office without salary and other benefits. So, pursuant to Section 50 of Rule 4 of the Revised Uniform Rules on Administrative Cases in the Civil Service, which directs the imposition of the penalty corresponding to the most serious charge in the event the respondent is found guilty of two or more charges or counts in view of respondent judge retirement on December 29, 2014. So here, the OCA recommended that respondent judge be meted the penalty of fine in the amount of 40,000 pesos for inefficiency on account of delay in resolving the motion for issuance of a whole departure order and gross ignorance of the law in granting the petition for bail without the benefit of a hearing, which amount shall be deducted from his retirement benefits. Now, the main issue is that whether respondent judge is actually guilty of gross ignorance of the law, gross inefficiency, grave abuse of authority, and evident partiality for granting the petition for bail without the benefit of a hearing. The Supreme Court said that they do not concur with the evaluation of the OCA that respondent judge did not err in allowing the accused to go home after his arraignment. They are neither persuaded by the respondent judge claims that there was no reason for him to detain the accused since there was yet no warrant issued for his arrest or that the petition for bail had been filed. Basic is the principle that upon setting a case for arraignment, the accused must have either been in the custody of the law or out on bail. Another basic principle is that the judge must conduct his own personal evaluation of the facts and circumstances which gave rise to the indictment, pursuant to Section 5, Rule 112 of the Rules of Court, and Section 2, Article 3 of the 1987 Constitution. Needless to say, the failure of the respondent judge to conduct a judicial determination of probable cause under Section 5, Rule 112 of the Rules of Court was exacerbated by his act in allowing the accused to go home without bail after arraignment. These acts were indicative of gross ignorance of the law and procedure for which respondent must be called to account. In addition, respondent judge's failure to conduct a hearing on accused petition for bail constitutes gross ignorance of the law. It is axiomatic that a bail hearing is a must, despite the prosecution's lack of objection to the same. In Balanay versus Judge White, the court said that it is basic, however, that bail hearing is necessary even if the prosecution does not interpose any objection or leaves the application for bail to the sound discretion of the court. Thus, in Villanueva versus Judge Puaya, respondent judge was held administratively liable for gross ignorance of the law for granting an ex parte motion for bail without conducting a hearing. Stressing the necessity of bail hearing, this court pronounced that the court has always stressed the indispensable nature of a bail hearing in petitions for bail, where bail is a matter of discretion. The grant or the denial of bail hinges on the issue of whether or not the evidence on the guilt of the accused is strong, and the determination of whether or not the evidence is strong is a matter of judicial discretion, which remains with the judge. In order for the judge to properly exercise this discretion, the judge must first conduct a hearing to determine whether the evidence of guilt is strong. This discretion lies not in the determination of whether or not a hearing should be held, but in the appreciation and evaluation of the weight of the prosecution's evidence of guilt against the accused. In any event, whether bail is a matter of right or discretion, a hearing for a petition for bail is required in order for the court to consider the guidelines set forth in Section 9, Rule 114 of the Rules of Court in fixing the amount of bail. This court has repeatedly held in past cases that even if the prosecution fails to adduce evidence in opposition to an application for bail of an accused, the court may still require the prosecution to answer questions in order to ascertain not only the strength of the state's evidence but also the adequacy of the amount of bail. Hence, it is altogether of no consequence that the order granting bail was made in the presence of the public prosecutor, and the latter made no objection or comment to the oral manifestation of the defense counsel. In sum, the court finds that respondent judge guilty of gross ignorance of the law and procedure in failing to make a judicial determination of probable cause and in failing to conduct a hearing on the accused application for bail in the criminal case, and gross inefficiency in failing to resolve complainant's motion for issuance of a hold departure order. So that would be all. Thank you so much for listening, and we hope that you will have a great day.